Great. Hi, everyone. Good evening. Thank you for joining us. This is our
晚上好，各位，欢
number.
迎大家参与我们今天会议。
Yes, I think we hear some interpretation.
Yes, interpreters, we're not interpreting quite yet. We haven't launched the interpretation channels. I know that this has gone back and forth a lot. But we're going to open, and then we're going to do the line about if you want to hear in this language, hit this button when we open, and then I'll launch the rooms, and then we'll go. So not quite yet.
Great. Thanks, Kessel. And thanks, interpreters. Welcome, everyone. This is our meeting number 20 of the Environmental Justice Council. And before we get started, I will pass it to Kessel from ERG, who's going to walk us through some logistics, including language interpretation.
Yeah, I'll handle that for now while Kessel's working on this interpretation stuff. No worries. Hello, my name is Sophia with ERG, a contractor supporting this effort. I'll first start with providing meeting logistics for our Zoom attendees. This presentation is available with virtual interpreters in Spanish, Portuguese, Mandarin, Vietnamese, Haitian Creole, and American Sign Language, ASL. We also have access to interpretation in this room in Spanish. Zoom attendees should use the interpretation channel indicated by the globe icon in their control panel to select their preferred language. English speakers should select English so they can hear any translated comments. Closed captioning will be auto-generated. If you are a virtual attendee and would like to use telephone audio for this meeting, please click on the small arrow next to the microphone icon, select switch to phone audio, and follow the directions provided. Kessel, are we ready on that end for the interpreters to introduce themselves?
I believe so. Jose, I think we're just going to have everyone say what they need to say in the main room, and then we'll launch the interpretation channels from there. So
that's correct. Okay, just give me one moment. I'll have people start. Bella, please, for Portuguese.
Olá, boa noite a todos. A reunião de hoje será oferecida em vários idiomas. Para participar em português, clica no ícone Interpretation e selecione português. Obrigado.
Okay. Cape Verdeans, Anilda.
Sim, boa noite. Meu nome é Zanilda, estou a ser intérprete de cabo-verdiano. Nós oferece interpretação para várias línguas. Se eu querer participar naquela reunião ali na crioulo, nós podemos clicar naquele ícone interpretação e seleciona Cape Verdean Creole, ou seja, crioulo de Cabo Verde. Obrigada, thank you.
Haitian, Kelly.
Bonjour tout le monde, bonsoir et réunion après-midi avec plusieurs langues. Pour capable t'aider la langue par qui c'est créole haïtien, ou cliquer dans l'icône qui en bas ou bien dans trois petits points ou choisir interprétation et puis sélectionner langue par là qui c'est créole haïtien pour capable t'aider en créole haïtien. Passez une bonne journée tout le monde, merci, bye bye.
Vietnamese on.
Một chút nữa ngay sau đây thì ban tổ chức sẽ bật kênh dịch và các anh chị hãy bấm vào biểu tượng quả địa cầu và chọn kênh Vietnamese để nghe phiên dịch song song tiếng Việt. Xin cảm ơn anh chị. Okay.
Mandarin, Shiyu.
大家晚上好，今天我们可以有普通话参加会议。如果你需要普通话，请单击口语图标，转折中文，这样你可以听到这个会议。谢谢大家。
Spanish, Mariana.
Hola, buenas tardes, sean bienvenidos a este evento, el cual cuenta con interpretación en diversos idiomas, entre ellos español. Si desea interpretación en español, haga clic en el icono Interpretation, un globo en la parte inferior de su pantalla y seleccione Spanish o español.
Okay, thank you, Kessel. That's all the languages introduced. Back to you.
Thank you. So the interpretation rooms should be launched momentarily. In the meantime, I'll continue with some logistics.
What number?
Virtual attendees can send an email to meetings@erg.com with any technical questions related to the meeting logistics. If you would like a translated version of the presentation slides, please go to the Environmental Justice Council website at the link provided in the chat. You will find a translated set of presentation slides there. This meeting is being recorded and will later be available for viewing through a link that will be posted on the Environmental Justice Council website at the same link. Virtual attendees can submit questions in the Q&A box. If you would like to make a comment, we have time allotted during the public comment sessions. Please wait for this time to make comments. During the public comment session, please raise your hand and I can unmute you. If you are commenting in another language, please speak into your language channel and your interpreter will translate the comment into English. Or you may type a comment into the Q&A box and I can read it out loud. Please keep comments under 2 minutes to ensure everyone has a chance to speak. In-person attendees who are asking questions, please make sure to speak into the microphone at the podium so virtual attendees can hear you. We can additionally bring you a handheld microphone if you're unable to use the podium. Additionally, for in-person attendees, we have activities for children available along the back wall, along with snacks and waters. For all speakers, please speak slowly to accommodate the interpreters. Please use simple language and minimize the use of acronyms. I would like to remind council members to only use the chat for meeting logistics and no other communication in accordance with open meeting law. We are also asking all council members to leave their cameras on for the whole meeting. Now I will turn it back over to Maria Belen Power to go over the agenda and roll call.
Thank you so much. And I want to thank our host, the Berkshire Innovation Center, our council members for coming, both virtual and in person, and our contractor, ERG, who is helping us with all of the logistics and making sure our meetings are as accessible as possible. And this includes language interpretation, so anyone can participate regardless of their English language proficiency. We've been really intentional about going to different corners of the Commonwealth and taking these meetings to where communities are at. And I know that it is a trek for some, but just really appreciate ERG for helping us make it happen, as well as the counselors. And so now I'm going to review the agenda. Great, so we'll do, we are at the agenda portion. We'll take public comments or questions at the beginning as well as at the end. It has been a practice that we've been doing in the past year and a half maybe to allow folks to speak. So if they can't stay for the whole meeting, they can participate in the beginning, or if folks want to speak at the end based on what they heard, they can also do that. We will then hear about cumulative impact analysis and community benefit plans. There will be the portion of Q&A or comments, and then we will adjourn and share next steps about our next meeting. And next, so now we'll pass it to ERG to help us with roll call.
All right, yes, so I will conduct the roll call to ensure quorum, and I'd like to remind virtual council members to respond verbally. All right, Kalila Barnett.
Here.
Madeline Fraser Cook. Melissa Harding Ferretti.
Present.
Cheryl Hawley.
I'm here.
Caroline Hahn.
Here.
Lydia Lau.
Here.
Marcos Luna. Peter Matthey.
Present.
Sophia Owen.
Here.
Great. Jen Salonetti.
Present.
Patricia Spence.
Present.
Ari Zorn. And Miles Gresham.
Here.
All right, so we have quorum, and I'll pass it back to you, Maria Belen.
Thank you. And now I will proceed with the approval of the minutes from the March 13th meeting. If I can get a motion to approve.
I move to approve the minutes.
Lydia, is there a second?
Patricia Spence, seconds.
Thanks. Are there is there any discussion about the minutes? Great, so I'll back to Sophia to help us with
All right.
with the roll call for the minutes.
Of course. So I'm just going to go back through that list. Kalila Barnett,
Approve.
Madeline Fraser Cook,
Approved.
Melissa Harding Ferretti,
Yes, approved.
Cheryl Hawley,
Approve.
Caroline Hahn,
Approved.
Lydia Lau,
Approve.
Marcos Luna, Peter Matthey,
Approve.
Sophia Owen,
Yes.
Jen Salonetti,
Approved.
Patricia Spence,
Approved.
Ari Zorn, Miles Gresham,
Approve.
thank you, and Maria Belen Power.
Approve.
All right, so with 12 yeses, the motion carries and the minutes are approved.
Thanks, Sophia. And now we are going to go to the first portion of public comment, or questions or comments. And again, there's some logistics that Sophia is going to help us with.
Thank you. So folks who are making an in-person comment, can you go up to the podium if you'd like to speak. If you're unable to walk to the podium, we can bring you a microphone. If you are speaking in a different language, an interpreter will translate your comments. For our virtual attendees, if you're speaking in another language, you can raise your hand, and once you are unmuted, you can speak into your language room. The interpreter will translate what you say into the English room so that we'll hear it translated into English. You can also submit written comments to the Q&A box, and we can read them out loud. A reminder to please keep your comments to 2 minutes. And finally, I'd like to remind everyone to speak slowly for our interpreters and keep your comments to 2 minutes or less so everyone has a chance to speak. And that's it for instructions on our end. Let's see. So I do see one question in the Q&A that I can read aloud. How will cumulative impact analysis evaluate effects of environmental/socioeconomic stressors on environmental justice populations and natural/capital and ecosystem services? And that is a question from David Dow. Kessel, do we have any hands, virtual hands?
I don't see any. If anyone wants to raise their hand by clicking on the raise hand button, feel free. But I don't see any right now.
And I don't see any comments in the room, so thank you, everybody. We'll now go into presentations, and there will be additional time for public comment, including questions related to the presentations at the end of the meeting.
Great, thank you. And so now we're going to move to our presentations about cumulative impact analysis and community benefit agreements. We have colleagues from the Department of Public Utilities and Energy Facility Siting Board, as well as my colleague Undersecretary Mike Judge, Undersecretary of Energy. And all of us will be covering different portions of the cumulative impact analysis and the community benefit plans. Let's see, so I think we start off with you, Undersecretary Judge, to walk us through the climate law and why we're doing this.
Yeah, sure. Assuming there's, I don't know who's running this slide. Okay, I can.
Yeah, you
just,
can say
okay.
next slide,
Okay, will
or
do.
it's running on the podium, whatever's
Okay.
easier for you.
No, I can just do it from here. That's fine. So if you go to the next slide, I think one more, maybe. There we go. So just to provide a little bit of context to folks, we have some fairly aggressive climate emissions reduction requirements in Massachusetts, similar to many other states in the region. And in evaluating how we achieve those reductions, we've developed clean energy and climate plans for 2025, 2030, and 2050. And in those plans, we have outlined one scenario as to how we would achieve those emissions reductions. And in looking at the power sectors, like the electric power generation sector in particular, we have to deploy tens of thousands of megawatts of generation capacity, solar and wind primarily, at least in the scenario that was modeled, in order to achieve those emissions reduction targets between now and 2050. And while we're on track for 2025, we have probably about, we have to increase wind capacity by about 20-fold from what we have today by 2030, and about double the amount of solar that we have by 2030. And we also have to deploy a lot of energy storage to integrate those resources. And we have to deploy a lot of grid infrastructure in order to interconnect those generation sources and storage sources, as well as accommodate all of the electric load growth that we expect to see from expansion of electrification in the building and transportation sectors. So as we convert homes and cars to electricity, we're going to be consuming a lot more electricity too. So a lot of pressure on us to do a lot very quickly and build a lot of infrastructure very quickly. So you can go to the next slide. So with that in mind, we started looking at, okay, what are the barriers to getting these projects built? Interconnection is certainly one barrier, and getting things connected to the grid. We are trying to examine how to address that through a number of different forums, grid planning and reforms to the interconnection process. But the other major source of delays and time constraints are permitting procedures. So when you look at the permitting process for energy infrastructure in Massachusetts, the process can be lengthy, unpredictable, sometimes duplicative. You have varying timelines. Some projects have taken a decade to complete. Historically, it's taken the Energy Facilities Siting Board between 1 and 4 years to issue an approval to construct, only after which projects can go obtain all of their individual local and state permits. There's lots of opportunities for appeal for every different permit that's issued to projects. Sometimes projects require 10 to 15 different permits, all of which have their own appeal routes. But then there's also some challenges on the side for communities too, in engaging in this process. Communities often feel they don't have sufficient or impactful input into the siting of major infrastructure projects. They may not have the resources necessary to fully engage in permitting processes. So in examining all of these different issues, we concluded that we would not meet our greenhouse gas emissions limits without reforms to the permitting process. Next slide. So in order to address this, Governor Healy issued Executive Order 620, and that was issued in the fall of 2023, and it established a Commission on Energy Infrastructure Siting and Permitting. The commission was required to advise the governor on accelerating the responsible deployment of clean energy infrastructure through siting and permitting reform, facilitating community input into the siting and permitting process, and ensuring that the benefits of the clean energy transition are shared equitably. The commission met 8 times or 15 times over 8 months, held 2 public listening sessions, received 1,500 public comments, and put together a set of recommendations that were delivered to the governor in the end of March last year. That then was, that formed the basis for legislation that was then drafted and moved its way through the legislature over the next 5 or so, or no, 8 or so months, with the law ultimately being signed by the governor in November of last year. The next slide. So as far as what the law did, we could spend all day talking to you about it. There's a lot of moving parts. It is, there's some complexity to how all of these things interface with one another. But I think there's two primary pathways that I want to kind of describe. The first is the path for large clean energy infrastructure. So large clean energy infrastructure is defined as generation facilities greater than 25 megawatts, storage facilities greater than 100 megawatt hours, all offshore wind related infrastructure that is state jurisdictional, so not the actual projects in the ocean themselves, but the transmission lines and utility equipment that's needed to connect them. And then large new transmission projects, substations, and the like. So some of this stuff, much of this stuff was already jurisdictional to the Energy Facility Siting Board previously. Some of it is new, but what will happen is the Energy Facility Siting Board will review all of these, all projects of this size will be required to submit an application to the Energy Facility Siting Board. And the board will review this and will issue a single permit decision that is encompassing of all state and local approvals required. So the board is going to be looking at all state and local environmental requirements and otherwise that the project would need to obtain and would issue a single decision. So that means that all state and local agencies that would otherwise have a permitting role now have to engage in an EFSB proceeding in order to get their thoughts on the project into the record. So they are automatically eligible to intervene in these proceedings, and they can participate by issuing statements of recommended permit conditions. So effectively telling the board, this is what we would do if we were issuing this particular permit to the project. All projects are required to undergo a cumulative impact analysis as part of their application to EFSB, and all projects that apply, a permit decision must be issued in less than 15 months from the determination that the board from the board that the application is complete. And then lastly, we've really streamlined the appeal process here. So as is the case today, all decisions of the EFSB are appealed directly to the Supreme Judicial Court. But because this is the only permit, you have one appeal going directly to the highest court in the state. Next slide. So for anything that is not automatically jurisdictional to the EFSB, we've classified this as small clean energy infrastructure. And I think that's sort of in relative terms. I think some of these projects are still relatively large. But this would, anything that is below 25 megawatts, storage facilities that are below 100 megawatt hours, and then any non-EFSB jurisdictional transmission and distribution projects, so smaller utility infrastructure projects, would be able to submit an application to a municipality for a local consolidated permit. So the municipality would still retain all authority to issue permit decisions for these projects, but they would be required to do so within a 12-month period and issue a single decision. So the municipality could, they'll receive the application, they could send it to the various boards at the local level. So you'd have a wetlands review from the Conservation Commission, maybe the zoning board, the planning board. They would all conduct reviews in parallel to one another, but then they would package up their decisions into a single decision that the municipality issues. And that has to be done within 12 months. If a local government feels that they do not have the expertise or ability to issue the permit themselves, they can refer it directly to the EFSB, and the EFSB would conduct the review on their behalf. Permit applications can also be reviewed by the EFSB following a local decision if a review is requested by parties to the local proceeding. So if they can demonstrate that they were substantially and specifically impacted by the local decision, they can ask that the EFSB review it, and then if the EFSB review is challenged, that would go directly to the Supreme Judicial Court. So effectively, for any clean energy infrastructure project, all lower court decisions and reviews of any permits that are issued have been eliminated, and now it's either the board and or the Supreme Judicial Court that are reviewing permitting decisions for these facilities. So really cutting out a lot of layers of the appeal process and cutting right to the chase so we can get final answers on these projects and decide whether they're going to be permitted or not. And so the responsibility for establishing the framework for the rules governing the local process falls on the Department of Energy Resources. So the DOER will not be actually issuing the permits to these facilities themselves, but they will be responsible for creating a standard permit application and uniform set of health, safety, and environmental standards that have to be used by local decision makers when they're permitting these smaller facilities. You go to the next slide. As far as community engagement, I think there's some notable things that are included in the law. So first thing I would mention is that it formally establishes the Office of Environmental Justice and Equity in statute. So the office was not established in law, in state law. So now it exists. It is permanent. It also provides the office with a specific mandate to develop guidance regarding community benefits agreements and cumulative impact analyses. The law also establishes the first ever community engagement requirements for permitting process, including documentation of efforts to involve community organizations and demonstration of efforts to develop community benefits agreements. It creates a new division of public participation at the Department of Public Utilities to assist communities and applicants with engagement and process questions that they have regarding DPU or EFSB proceedings. And it also establishes the new division of siting and permitting at the Department of Energy Resources to assist communities and project applicants with engagement and process questions at the local level. Lastly, it also establishes an intervener financial support program. So financial support will now be available to under-resourced organizations that wish to participate in EFSB or DPU proceeding and that are granted intervener status. So this could be any number of organization types could seek this funding. And if they're granted intervener status in the proceeding, they could receive financial support. Notably, municipalities with a population of 7,500 or less are automatically eligible for financial support. So if a large transmission line is coming through a small community or a large battery storage project is coming into a small community and is in front of the board, that community would be able to automatically intervene into the proceeding and would be automatically eligible for financial support so that they can fully participate in the proceeding. Next slide. I won't spend a lot of time on this, but just quickly, there's some additional reforms maybe worth noting. So the Executive Office of Energy, Environment, and Environmental Affairs is required to establish a site suitability methodology to inform state and local permitting processes about the suitability of particular locations for clean energy development. So that's the goal of that is really trying to help developers avoid, minimize, and mitigate mostly environmental impacts, but it does actually include some social impacts as well in the criteria. There's some new seats on the EFSB, so the board has been expanded and some seats have been replaced a bit. All EFSB jurisdictional infrastructure is now exempt from MEPA reviews. So they won't undergo a MEPA review, but that the MEPA, the review, the environmental review of these projects will be taken up by the board. And then lastly, some legacy authority that had rested, siting authority that had rested with the Department of Public Utilities has been transferred over to the board. So some authority over comprehensive zoning and eminent domain issues, which had been retained by the DPU, is now under the board's authority. Next. Just to kind of explain sort of the different roles and responsibilities here, there are 5 primary work streams that have emerged out of the legislation. And what you can see here is those 5 separate work streams and who is responsible. So starting on the left, EEA is responsible for establishing that site suitability methodology and guidance. EEA is also responsible for developing cumulative impact analysis and community benefits guidance. The DOER is responsible for siting and permitting rules for municipalities. EFSB is responsible for siting and permitting rules at the state level. And then DPU is responsible for establishing the intervener funding support program rules and parameters. So 3 agencies here, but there's a lot of other agencies that are being involved in this process as well. But EEA, DPU, DOER are all in very close communication with one another. I should mention that the EFSB is staffed by the DPU's citing division. So when I say that, the board, the EFSB rules are also being worked on by DPU staff. But there's a lot of overlap between these different rules, and we're really trying to be coordinated as we develop them. Next slide. And then finally, next steps here. So we did have some public stakeholder sessions in April and May. We've solicited comments on a number of straw proposals that we put out on a variety of different topics. We're in the process of reviewing those, drafting the regulations that we need to develop. We are required to promulgate and conclude all of our rulemakings by March 1st of next year. So it's a tight time frame given all the work that we have to do. We expect that draft regulations will be released for public comment late summer or early fall. So stay tuned on that. But we are continuing to try to engage with stakeholders, continuing to take feedback on the direction that we're heading. There's a number of different websites where information can be found. We've listed one link here. This is an EEA page where you can, everything is just a couple clicks away on this page. So if you go to that page, you can find information on all the different straw proposals. There's a few different email addresses too, where you can submit questions or comments. And we have a system to route those to the right individuals if something goes to the incorrect email address for a particular inquiry. But so we have a process in place to make sure that inquiries are being directed to the right place. But yeah, a lot of work to be done. Looking forward to engaging with folks further, and a lot of things to pull together in the next few months in order to implement this.
Thank you. Thanks, Undersecretary. Before we go, so we're gonna have a public comment and question at the end of the meeting, but I do want to give some space to the counselors, to the EJ council members, if there are any comments or questions. I know that was a lot, and after this, we'll have the DPU present, and then the Office of EJ will present. So I just want to give the opportunity to ask Undersecretary Judge any questions or comments. And I see Miles. Go ahead,
Thank
Miles.
you, Undersecretary. And thank you, Undersecretary Judge, for the presentation. Just curious, what does the process for creating rules around community benefits look like, and when do you think that those rules will be finalized?
I don't know if you want to touch on that, but
Sure.
yeah.
So the Office of EJ and Equity is tasked with drafting guidelines that then will be considered by the DPU. And the DPU is in charge of drafting and finalizing regulations that will then be implemented. I think I got that right.
Yeah. I would just note too, I think, we haven't finalized any rules, but generally speaking, when people ask about community benefit plans and agreements, what I say is that they are not explicitly required in order for a project to obtain a permit. That said, having a community benefits plan in place or a community benefits agreement in place is likely extremely helpful for moving your project through the permitting process. And I think will be looked upon very favorably and should help resolve a lot of potentially contentious issues that would otherwise emerge in a permitting proceeding. So I think the goal of the guidance and guidelines that are being developed in large part is to kind of help people understand how to structure this, how to go about in getting into community benefit, establishing community benefit plan and agreements. But it is not explicitly required. I think projects would just have a much more uphill battle if they have not developed a community benefits plan or entered into a community benefits agreement. Is that fair to say, you think?
Sure, yeah. Thanks, Mike.
Thank you.
So I think I see Sophia has a hand up. Is that right?
Yep. Thanks, Undersecretary Power and Undersecretary Judge. I guess I'm wondering, I know you're on a tight timeline and you're reviewing what you heard back from folks on the straw proposals. Is there a plan to share an update in between the review of the straw proposals and then the release of the regs? And if so, is that going to be on each topic, or is it just going to be cumulative impacts and CBAs? And then my second question, actually maybe better held for later, so never mind.
Yeah, I can start and others can chime in and add. I think we aim to have some more opportunities for engagement and discussion about the direction that we're heading before we release draft regulations. We are up against the clock and we have a lot of internal review and drafting that we need to do. I think it's possible that next month we will be in a better position, having hopefully drafted a lot of our proposed rules. Notably, the Department of Energy Resources, because they were staffing up, still did not put out a kind of concrete straw proposal on the direction they're heading. So I think the plan right now is for them to release that for public comment sometime in July. But I think also for the EFSB team and EEA team, we are scheduling some kind of targeted meetings with folks who were involved in the commission, as well as groups that we know have been actively following the process so far. So we're trying to have some more one-on-one meetings and kind of work through some of the thornier, more complex issues that we're dealing with. So I think we expect that there will be more opportunity. I don't know exactly what that's going to look like yet, but we are trying to have as much additional public engagement as possible, but it is just a very constrained timeline. I don't know.
Yeah, I wonder if the council is interested, we could come back in 2 months for our next EJ council meeting, which is in August. So I guess based on the council members, but also if we have substantively something to share, that can be, yeah, I'm just thinking out loud, but we can think about it also. Kalila.
Yeah, I guess kind of to that point, I'm not really clear about is there a specific ask of the council or some mechanism for us to be weighing collectively as a body? I'm like, what are we doing here with this information?
I mean, I think, so I guess that was the first part of the presentation. Then the DPU is gonna speak about their portions, and then we're gonna speak about our portions. And so I think that any feedback that you have would be helpful. If also, if you want, we'll have this the information available. If people want to sit with it and think about it, and we can, schedule another meeting or get feedback in writing or have one-on-ones. We're trying to make sure that this is as reflective of the feedback as possible. So if there are any red flags or concerns that people have, especially in regards to environmental justice, we would love to hear that so we can figure out how to address them.
Okay, yeah, it would be great if maybe we could leave a little bit of time for the council to discuss before the meeting closes, how we might want to, if people just want to weigh in individually, or if there's something more collective that we would want to do.
Sure, that sounds good. All right, so we'll go to Commissioner Rubin and her team to go through the DPU EFSB siting and permitting.
Excellent. Good evening, everyone. I am Stacy Rubin, and I'm one of 3 commissioners at the Department of Public Utilities and currently a member of the Energy Facility Siting Board. Thanks to the Office of Environmental Justice and Equity and the EJ Council for the opportunity to share this space with you tonight. Next slide, please. So we are required by the 2024 Climate Act to change the board membership. And I want to uplift a particular change that I think this group might be interested in. So the board will be, comprised of the new members by March 1st of 2026. That's going to include a representative with expertise in Indigenous sovereignty or environmental justice, and also adds a member with municipal expertise, as well as a member with expertise in public health. The 2024 Climate Act requires the board members to balance a variety of factors, and it also gives the siting board the authority to review battery energy storage systems. So as Undersecretary Judge mentioned, the siting board will issue the consolidated permits for clean energy infrastructure, and municipalities will issue the consolidated local permits. The law requires the siting board and the municipalities to make a decision by a certain date. Those dates are a little different depending on specifics relating to the project. And if that deadline is not met, then the project is considered to be approved. This is called the constructive approval. The Energy Facility Siting Board plans to meet all the deadlines, though we are developing a plan to issue a constructive approval if necessary, but that's not what we're planning to do. The law also requires a project applicant to engage in pre-filing consultation with communities. There's some specifics that my colleague Veena Dharmaraj will walk through, and it directs our agency to establish a program for intervenor grant support. And that in particular is going to allow for funding for attorneys, community experts, and other administrative costs to be covered. The 2024 Climate Act also requires the siting board to establish regulations for cumulative impact analysis. And if we move to the next slide, I'll talk about what the goal of that analysis looks like. So the analysis will include a report that is produced by the project applicant, and it will involve a tool that's developed by the state and our contractors. So the goal of the tool is to be transparent, to allow stakeholders to get access to information about a project early on, and to be simple for a project applicant to use to plug in information about a project and see how it scores. The cumulative impact analysis looks to existing environmental burdens and public health consequences for a local place. This is called a specific geographic area. And the applicant is required to identify if there's a disproportionate adverse effect of a proposed project on that specific geographic area, and if so, to propose remedial actions. Unlike the 2021 Roadmap Act that required analysis of impacts on environmental justice populations, the 2024 law requires a focus on what's called unfairly burdened areas. So we're working very closely with the Office of Equity and Environmental Justice on the cumulative impact assessment tool and process, and then we will develop regulations that will be promulgated by the board. Next slide. So the board is going to be requiring an evaluation of cumulative impacts for all energy projects. The Act left many of the specific details for the regulatory and implementation process. So your feedback tonight and afterward is incredibly helpful. So again, the various government agencies have been working together and getting stakeholder input on methods to implement the CIA requirements. So we've studied existing approaches that the Mass Environmental Policy Act Office uses and the Massachusetts Department of Environmental Protection. We've also looked at cumulative impact analysis for agencies around the country, and we've looked even globally. This slide reflects the central task of any cumulative impact method. What should be measured and how? In other words, what data should be used to evaluate impacts on the environment and public health for both existing conditions and the addition of the proposed project? We're focusing on 4 types of indicators: population characteristics, especially people who are most susceptible to harm from pollution. 2 is the built environment and its pollution sources. 3 is vulnerability to climate change impacts in the project area. And 4 is ecosystem conditions and potential harms. Next slide. If you can just click through, this is animated. So once relevant indicators are identified, the next major question is how to incorporate that data into the analysis. So this diagram is a conceptual flowchart of an approach we are considering and are seeking stakeholder input for. Sorry, if you could go back, thank you. We are still hearing from stakeholders on the concept, but just to boil it down, the CIA approach would first create a new statewide map of unfairly burdened areas. It would look somewhat similar to the existing EJ viewer map, but it would not be tied to existing environmental justice population definitions. We would then evaluate the proximity of the proposed project to the unfairly burdened areas. Next, we would quantitatively evaluate the existing environmental and public health impacts in proximity to the proposed project site or the site routes. And then we would add those expected to result from the project. Next, the applicant would propose additional mitigation if the project materially exacerbates environmental or public health threats. Last, the applicant would prepare the CIA report with both quantitative and qualitative information. Again, there's a lot of work to be done, and we welcome your thoughts on what we should be doing better. Next steps is to include drafting regulations that will talk about what we will do as the board to evaluate the results of the tool. Again, there's going to be plenty of opportunity for additional public comment. And we're taking this flowchart approach and doing a case study analysis of a transmission line to test out how the model will work with a real-world project that has already been permitted and constructed. I will now turn it over to my fabulous colleague, Veena Dharmaraj, who directs the new DPU Division of Environmental Justice and Public Participation.
Thank you so much, Commissioner Rubin, and good evening, everybody. I'm going to be providing a very high-level overview of the pre-filing requirements as well as the Intervenor Support Grant Program. So can you move on to the next slide, please? Thank you. Starting off with the pre-filing requirements, the 2024 Climate Act requires EFSB to establish pre-filing requirements for clean energy infrastructure facilities that fall within EFSB's purview. The objective of the pre-filing engagement is to establish explicit pre-filing outreach requirements and ensure that there is consistency in outreach practices across projects before the application has been filed with the board. Pre-filing outreach will provide stakeholders with an opportunity to influence project design all through the project development, as well as encourage wider public participation. The statute calls for pre-filing consultation with local as well as state permitting agencies and the Massachusetts Environmental Policy Act Office. And the objective behind this is to receive feedback on compliance with regulatory requirements that the project proponent needs to meet. It requires the applicant to use multiple outreach channels, including public meetings, to inform stakeholders about the project. Applicants are also required to provide evidence that pre-filing consultation with stakeholders, including community groups, local as well as state permitting agencies, abutters, and other stakeholders have been satisfied. The 2024 Climate Act also creates the DPU Division of Public Participation, or DPP. It tasks the DPP with assisting stakeholders with navigating pre-filing requirements in coordination with the Office of Environmental Justice and Equity at EEA and facilitating dialogue among stakeholders during the permitting process. Next slide, please. The second piece is about, again, a very high-level overview of the Intervenor Support Grant Program. The intent of the Intervenor Support Grant Program is to provide financial assistance to eligible entities who are unable to participate in proceedings either before the DPU or the EFSB because of financial hardship, or in sometimes lack of procedural knowledge as well. It will allow grantees to cover fees for attorneys, expert witnesses, including community experts, and will enable diverse voices as well as viewpoints to be considered all through the decision-making process. The 2024 Climate Act establishes a minimum set of eligibility criteria for applicants to receive funding. This includes an applicant's lack of financial resources to intervene and participate in a proceeding. Secondly, when an applicant has, it also looks at whether an applicant has previously intervened or intervened since creation of the program. This does not qualify or disqualify the applicant in any way. This criteria is just required by statute and is one of the several factors that will be taken into consideration. Municipalities with a population of less than 7,500 people applying for a grant for proceedings related to either a large or small clean energy infrastructure facility are exempt from this criteria. Other eligibility criteria include how the applicant proposes to substantially contribute to the proceeding. It looks at whether they have an achievable, clearly stated plan, and if they have a unique perspective that is not adequately represented by other parties to the proceeding. Finally, the amount and the amount as well as how reasonable the funds requested are in the proposed budget items will be factored in. The straw proposal on both the pre-filing engagement requirements and the intervener support grant program have a lot of additional detail. They're available on our website. I'm happy to answer any questions now and welcome your feedback today as well as in the coming months. Thank you.
Thanks, Veena. I'm wondering, initially I had paused after Undersecretary Judge spoke, but I think it might provide more clarity if we continue through the presentation and just open it up for questions afterwards. So I'll just keep moving along. So now it's the Office of EJ and Equity. And so we'll be talking about the cumulative impact analysis, and then my colleague Saina will be covering community benefit plans. Next. Great, so we'll go through some key concepts, the purpose, how to develop a CIA, principles, resources, and questions. Next. Great, so part of what my colleague Undersecretary Judge mentioned is the Office of EJ and Equity was enshrined in the statute by this law, by the 2024 Climate Act. And as you all know, part of our task is to implement environmental justice principles, which are 1, the meaningful engagement of all people, and 2, the equitable distribution of benefits and burdens. Next. So I won't go through all of the key concepts that we all are probably very familiar with, but I will just highlight the term indicators, which are specific stressors that are used to assemble quantitative and/or qualitative measures of conditions and trends to assess the state of the environment, public health, socioeconomic, cultural, or the built environment to gauge progress. So this is going to be really important when we're developing the CIA. And then the second one that I want to highlight is the unfairly burdened area. This was mentioned in the statute, and it's an area or population that is impacted by existing unfair or inequitable environmental burden and related public health consequences. So that language is in the statute. And the next, I guess I'll go to the next slide. So what is a cumulative impact analysis? I'm not going to read this whole thing, but it is basically a written report that assesses the applicants, the impacts and the burdens in that community. Not limited to the impacts of that project, but to cumulative impact, including future conditions that are projected. And the analysis has to include A, the environmental and public health impact, B, increase or reduce the effect of climate change, how the project increases or reduces the effect of climate change on such geographical area. And 3, propose potential remedial actions. Next. So the purpose is really to provide a framework and a clear guidance or roadmap for project proponents to be able to use a tool and to be able to either show the impact that the project will have and the benefits as well, and that will guide any of the mitigation or community benefit plans. Next. So how to develop a CIA, a cumulative impact analysis. So there are a few components. The first one is identifying a baseline. And so what are the current conditions, both environmental and public health, of that community? Then it will need to consider the indicators or stressors, both existing and future. And it will be critical to understand what other projects are already in place or planned in the near future. Next. I think. Yes, no, back. Yep. So identifying community baseline for comparison. A pretty important piece of that will be establishing a clear baseline of what are the current existing environmental, health, socioeconomic conditions of that community. And to help that, the Office of EJ and Equity is creating a tool that is very similar to the California tool, which is called Cal EnviroScreen. And we will have a similar tool that will be called Mass EnviroScreen, but it will help us do the same work of mapping these communities based on different criteria and different indicators. And so by integrating the tool, the project proponents will have access to reliable data, so they can have a framework that they can use, and it is clear, and they have data that's accessible, and that the results are data-driven. Next. So the indicators and stressors, we've put them into 4 buckets of categories. One is the built environment. The other one is climate change. The next one is natural environment. And the 4th one is population characteristics. And these are similar to what Commissioner Rubin shared. And the categories really help us understand the full spectrum of the impacts that a project can have in a community. Next. So we'll go through some examples. This is not a full list of everything that every project is going to have to analyze. These are just examples of potential indicators. So for the built environment, it could be groundwater discharge permits or storage tanks or energy generation and supply. For climate change, it could be climate risk rating, if I can read from here, areas within sea level rise, inundation above mean high water level. It could be maximum annual daily rainfall within overall project useful life. So these are just examples of what can be the indicators under this category. Next. So the natural environment, these are some options for that bucket, and then the population characteristic, we'll leave them up for a couple seconds just for you to glance. And again, so we'll have these slides available, but it could be impacted areas of critical environmental concern. impacted surface water supply watershed. You can tell I'm reading the ones that are lower on the screen. Or for population characteristic, low birth weight, current asthma rates. So these are some examples of the indicators that could be included in the tool. Next. So the awareness of combined impact. So each stressor really needs to be assessed cumulatively, meaning not just based on one project, but in combination with past, present, and reasonable foreseeable future in a given specific geographical area. And our goal is really to shift from looking at projects in isolation to really recognizing how layers of exposure and risk compound in specific communities over time. Next. So understanding existing and foreseeable future projects, the CIA, the cumulative impact analysis, will account for not just the proposed project, but the impacts of existing and planned development in the area. And evaluating reasonably foreseeable future projects helps us identify potential compounding impacts and avoid blind spots in project assessments. Next. And so we'll need to look at geographical and temporal boundaries. So exactly establishing which are the the clear geographic location and the temporal boundary. So how far back are we looking at? What are the areas that we're looking at? And these boundaries will help us define the scope of the analysis. So these are the 5 principles that we think are important in the development of a cumulative impact analysis, and they include applicable to the new and modified energy infrastructure. They need to be engaging with community early and often, the tools and methods for assessing cumulative impact. Then there's a cumulative impact process, and then there's the report. And so the proposed process follows these 6 steps. So it would be first to gather the baseline data, including public tools and community input as well. Number 2, in consultation with the community, identify all potential impacts of the project. Number 3, evaluate the significance of the impacts. Number 4, score each site or route to assess cumulative impact potential. Number 5, assess mitigation and management strategies. And number 6, prepare draft cumulative impact analysis report and submit it to the EFSB, which may be further refined through that process, through the EFSB process. So I'll just end by saying, this is not meant to be a check the box process, but it's meant to be a useful and meaningful tool for project proponents to be able to do what they intend to do and to build these projects, but to do it in a way that does not add layers and layers of impacts on communities that are already overburdened. And then as it relates to community benefit plans, which my colleague Saina will touch on. So now I'll pass it to her so she can cover community benefit plans.
Thank you, Undersecretary, and good evening, everyone. Next slide, please. So as Undersecretary Power mentioned, I will be speaking about community benefit plans and agreements, or CBPs and CBAs, which are another key tool to helping ensure that host communities don't just carry burdens, but also gain real lasting benefits from energy infrastructure projects. Next slide, please. So what is a community benefits plan? A community benefits plan is a document prepared by project developers that will specifically outline how the developer will engage with the community impacted by the project and what specific benefits the project/project developers will provide to the community hosting the project. And community benefits are commitments by the project developers that provide meaningful and measurable benefits to communities, especially those who are historically disadvantaged, overburdened, and underserved. Community benefits are the tangible and lasting outcomes that a project delivers in response to the priorities, needs, and concerns of the communities it is impacting, and these benefits are intended to address both the potential impacts of the project and the specific needs of the local community. Next slide, please. And so we're talking about community benefit plans and community benefit agreements, so I just want to break down the differences between the two. And so a community benefits plan, as the name suggests, is a plan that shows how a developer intends to support the community, while a community benefits agreement, or CBA, is a legally binding contract, usually negotiated between the developer and representatives of the community. And so, in other words, the CBP is a framework and the CBA is a formalization of the commitments outlined in that framework. And it is usually an outcome of a CBP. Next slide. And so many communities in Massachusetts, especially unfairly burdened areas, have historically shouldered the burden of pollution and industrial infrastructure without seeing the benefits. And CBPs can help to shift this dynamic. They reframe clean energy development as an opportunity to center community voices, reduce harm and displacement, build local wealth and capacity, and reduce legal, political, and community risk for developers. However, to do this effectively, community engagement must be done right. Next slide, please. And so we've identified these core principles of how to effectively engage with communities, because how project proponents engage with the communities matters just as much as what they commit to. And so these are the key principles that are or can shape an approach to engagement that is inclusive, respectful, and rooted in equity. So the first one is to begin early, meaning communities should be engaged early in the project development process before decisions are finalized to shape meaningful outcomes. It also helps to ensure that voices traditionally left out are heard and involved from the start. The next principle is to ensure inclusion, meaning impacted disadvantaged communities and those historically marginalized should be prioritized. Engagement should remove barriers, consider logistics such as language, location, timing, digital access, so everyone has a fair chance to participate. It should also build trust through transparency, meaning that trust is earned, and clear, honest, and timely information helps communities understand what's happening, why, and how it will affect them. And being transparent also means acknowledging concerns and addressing trade-offs openly. The next principle is to respect cultural relevance and ensure that engagement efforts reflect and respect the community's language, values, history, and communication styles to ensure that it is meaningful and accessible. This means providing materials in the right languages, partnering with trusted local organizations, and creating space where people feel respected and safe. The next principle is to make engagement ongoing. As the Undersecretary mentioned, engagement should not be a checkbox. It is continuous, iterative, and a two-way dialogue throughout the project development, siting, and permitting. And the last principle is to embed accountability, meaning communities deserve to see how their input shaped outcomes, and there should be mechanisms to track progress, honor commitments, and empower community oversight. And so with these principles in mind, we're going to walk through how we envision them to be applied in practice when developing a strong community benefit plan. Next slide, please. And so while every community is different and may require different or may have different needs, this structure ensures a consistent approach to transparency, inclusion, and accountability. Developing a strong CBP is both a process and a partnership. It's about working with communities, not just informing them. So each of the steps on the slide are intended to be flexible enough to adapt to local context, but also structured enough to ensure this process leads to real measurable community benefits. There are 6 steps that we've identified. The first being stakeholder mapping and community identification. So identifying who will be impacted by the project, not just geographically, but also considering language, cultural groups, and past community experiences with infrastructure. And then step 2, to develop a community engagement plan, which is a structured plan that outlines how, when, and with whom engagement will happen. It should reflect the community's needs and not just the developer's timeline. The third step is to conduct pre-filing outreach, which should occur as outlined in the DPU's presentation / draw proposal on pre-filing engagement. And this is the opportunity for developers to listen, learn, and build trust with the community. Step 4 is to create co-create benefits commitments, and it's using what the developers have heard to shape proposed benefits with the communities that reflect their local priorities. And having collaboration during this step helps to build ownership and relevance. And then step 5 is to develop a written public CBP document. And so this is the step where the developers are drafting the CBP in plain language and making it available for public review. This document should be shared widely in community centers, libraries, online, and should be made widely available so that project proponents are being transparent about what's included and how it's connecting to community's feedback. And then lastly, project developers should be formalizing accountability, which means building in clear commitments, timelines, and metrics, identifying how progress will be tracked and reported, and then where possible, we highly encourage developers formalize these commitments through CBAs or other binding mechanisms to ensure long-term accountability. Next slide, please. And so a strong CBP goes beyond just listing ideas or intentions. A well-structured CBP should clearly show how these commitments will be put into action and how communities can track that progress over time. It should clearly describe each proposed benefit and answer 2 key questions: what is being delivered and who it is intended to serve. It should also provide a clear timeline for benefits delivery that is tied to specific project phases. This will help set realistic expectations and ensure that benefits are being distributed across the life of the project, not backloaded or just overall vague commitments. And it should identify the responsible parties, name who is accountable for delivering each component, whether it is the project proponent, a subcontractor, or a community partner. It should also outline funding sources and budgets and include SMART T milestones, milestones that are specific, measurable, achievable, relevant, time-bound, inclusive, and equitable, as these milestones provide a roadmap for delivery and make it easier for communities to evaluate whether commitments are being kept. And together, these components make the CBP not just a proposal, but a public commitment to equity and shared benefits. Next slide, please. And now I'm going to try to bring this CBP framework to life with.
Sorry, we hear one of the interpreters in the English room.
Yes, let me look and see who that might be.
I'm sorry about that pop-up. It should be good now.
I don't see anyone in the English room, so they might have switched back. So I think we can keep going.
Great, thank you. So now on the slide, you'll see some examples of common priorities or examples of commitments that could be made. These commitments fall into 4 key categories that reflect justice-centered outcomes. The 4 categories, or the 2 on the slide, are environmental justice and equity, and then an economic development and workforce. And so examples under each category could include a local hiring plan with clearly defined goals for participation from EJ populations, funds for the installation of air quality monitors in a community-led environmental health monitoring program, or project labor agreements, training and apprenticeship programs, or even workforce development investments, including critical supportive services. Next slides, please. And then the other 2 categories are infrastructure and community support and environmental and public health protections, which can include investment in public open and green spaces, investment in community centers and parks, local health organizations, and substance abuse services, or the integration of wildlife and habitat protection into the development plan, or including systems for monitoring environmental impacts, including air, water, and soil quality. Next slide, please. And so those were examples of what meaningful community-driven benefits could look like, but they should be thoughtfully designed and directly responsive to the community's needs. And they should be designed with systems in place to make sure they're delivered, and that's where accountability comes in. A strong CBP should include clear systems of oversight that ensure benefits are delivered as planned and that communities have a forum for monitoring progress. Proponents should establish clear accountability mechanisms that may include a monitoring and reporting schedule aligned with project milestones, designated points of contact for community members and regulatory bodies, public-facing progress reports published at least quarterly and made available in multiple languages and accessible formats, or opportunities for communities to review progress either through advisory committees, listening sessions, or other forums. And when possible, projects are encouraged, or proponents are encouraged to take the next step by entering into community benefit agreements with community-based organizations, municipalities, or other coalitions that reflect the needs and interests of impacted residents. Next slide. Okay. So to conclude my presentation, the CBPs are powerful tools to make sure that the transition to clean energy is not only fast and effective, but also inclusive and community-led. But for these tools to work, we need your help in shaping how they're used, and your voices are essential to creating guidelines that reflect real community needs, priorities, and values. And with that, I will turn it back to Undersecretary Power to open and facilitate the discussion.
Thanks. Thank you, Saina. I think now we'll open it up to the council. It is 7:50. So let's open it up to the council. I know it's super tight. We end at 8, but I do want to give the public also to ask questions. So we'll do 5 minutes. And if there are other questions, we can also set up a special meeting to go through these questions or comments if folks want to do that. I think I see Melissa.
Yeah, I mean, I don't really have a question. I just want to make a comment. I mean, I think thank you for the presentations. They were very robust. There's a lot of information, of course, there to digest and to, sort of look over and read over. I think with the energy, the portion, the first with the permitting, I think I'd particularly be interested in really looking closely at that plan. I think it's a great idea, of course, to make projects easier, but at the same time, I have a worry that making them easier can also make it be more quickly violations on the tribal homelands and other environmental justice communities. So I just hope that that's, something that's being looked at and really thought about when we say, let's make permitting easier for certain projects. So thank you. I'll obviously dig in and have to do some more research because again, it is a lot of information and I appreciate all the work you're doing here. And thank you.
Thanks, Melissa. Appreciate it. Is that your hand, Sophia? Sorry, it's hard for me to see.
Yeah, sorry, my hand matches the paint color on my walls. So yeah, thank you. I know this is a ton of information and we always have so little time. 2 things. One, to just follow up on Melissa's point. This is something that I know I have said before, but particularly given the the specific ways in which all of these processes will impact tribal and indigenous governments and organizations and play out differently in Indian country. And since there wasn't an indigenous representative on the governor's siting commission, I just want to ask again that the right folks from that community be brought together to talk about the issues that are particularly important and distinct for them. And the other thing that I wanted to ask was just as a process point, since it sounds like there are a number of us who do want to continue to talk about this and potentially to provide feedback, if someone who is more up on process than I am can just remind us how we ask for a special meeting or how we do that, given the confines of the open meeting law and everything else, that would be super helpful. Thanks.
Yeah, I mean, I think we can schedule a special meeting. We just have to make sure that we announce it with plenty of time and that we provide the accommodations like language, remote. But I think that's possible for us to do if folks were interested in that. We can, go back and look at the logistics, but I'm sure we can schedule a special meeting. If we want to go through more detail, maybe one thing that occurs to me is maybe you all have, want to read through this in a couple days and send us over specific questions that you might have. And then that way we come prepared to answer those questions with the people that will be implementing whatever piece that you're interested in. I don't know, and folks can chime in if you have different ideas on how we can make this meaningful.
Thanks, Maria Belén.
Great. Is there another hand? Oh, yeah, go ahead, Jen.
Yeah, I wanted to note that I appreciated the exemption for population or municipalities less than 7,500, because that's almost every municipality in Berkshire County. So receiving that financial support is really helpful in this circumstance. And then I'm also curious if I think I heard at the end that there's only proponents are encouraged to take steps to engage with CBOs. This is not required, it's just encouraged. So why would that not be a requirement?
I think the concern from members of the commission that was expressed at the time was the potential for community benefit plans and agreements to be used as sort of a veto by municipalities. So if a community didn't want a project that might be, let's say, I'm just going to use an example here. Let's say there is a transmission line that needed to be sited in a particular community, and there really were no other options, and it's a kind of a grid reliability issue and concern. But some members of the municipality do not want that project, and they were unwilling to enter into a community benefits agreement or plan with the utility. I think there was a concern that that could just be used as an effective veto on something that could be a critical piece of infrastructure. Mm-hmm. So the utility could proceed forward with that under the framework that we have, but they're going to have to explain why haven't we entered into a community benefits plan or agreement here. And I think if it's made clear to the board that there is just opposition that isn't well founded, then I mean maybe they could approve the permit. But like I think it's something that would just be hashed out in a proceeding. That was the concern that was expressed at the commission level, and I think that's sort of why it wasn't adopted as a firm requirement. But I think it's going to be viewed. It's going to be it's going to get a lot of heavy weight. Like if you have not entered into a plan, I think there's going to be a lot of questions asked. Why? Why haven't you been able to negotiate something with the community?
Thanks. I don't see any other hands from the counselors. So we are going to move. Sophia, I don't know if there are any hands up or comments.
Oh, I see Madeline Fraser Cookhouse.
Oh, sorry. Go ahead, Madeline.
Hi, yes, just a quick comment. Having heard the presentation on permitting and the challenges and how much time that could potentially take, and some of the solutions for timing on permitting, and then the presentations on CBA, I think that there's a lot that we need to discuss and kind of hash out about how you thread the needle on making sure that projects don't get interminably delayed, and that they come to a resolution. CBAs are amazing tool, and I've seen them be used very effectively, but they also can take a very, very long time and be really complex as you start to navigate, meaningful community engagement. So just a comment that I do believe that we need to have deeper conversations amongst this group around how to effectively thread the needle and make sure that we are um, facilitating projects that meet our climate goals while also making sure that we're engaging meaningfully and using CBAs as an effective tool for benefits going to communities from those projects. So more comment than anything, but something that we definitely, I feel, need to discuss further.
Thank you, Madeline. I think that makes sense. And that might be that and the other reasons to have a special meeting, perhaps next month, in between now and August.
Yeah, I would definitely appreciate that. This is a lot to digest, and I have more questions already, but I know we're almost out of time. And so, if it was possible for the council to have the slide deck, I think that would be really helpful because it's very content heavy and informative.
Yeah, for sure. So we'll send the slides, and we can send an email out with logistical information about scheduling a July meeting. And now pass it to you, Sophia, if there's anyone online with a question.
Yeah, while we wait to see if anyone puts their hand up, I'll just quickly read through these comments from David Dow. I would recommend ecological, economics, and ecosystem-based environmental impact statements. A good case study is the US EPA headquarters. Sorry, I'm going to mispronounce this. Waquat Bay Watershed Ecological Risk Assessment, which considered climate change, fisheries depletion, nutrient pollution, nitrogen and phosphorus, toxic chemical contamination, microplastics, and perfluorinated chemicals, cyanobacterial toxins, methylmercury, etc., plus affordable housing, environmental justice. Bio for Climate offered an online course on ecological economics, and Les Kaufman at Boston University applies it to real-world environmental challenges. As a resident of Cape Cod, where we have a County Cape Cod Commission Regional Policy Plan / Climate Action Plan, plus town meetings, select board funding for action at the grassroots. How will the CIA flowchart approach for energy construction coordinate with grassroots endeavors like bringing offshore wind energy onshore for connection to the regional energy grid? So that was a variety of comments from David Dow. Are there any other questions online? Kessel, do you see anybody?
Sophia, I think we have one in person.
Oh, yes, of course. I can bring you this microphone.
I'm Karen Pilto from Berkshire Funding Focus, and I help people in Berkshire County become aware of and more competitive for state and federal grant funding. So of course, very interested to see how the Intervenor Grant Support Program rolls out. But I wanted to acknowledge for folks here and folks online who perhaps are not aware that the Berkshire Innovation Center sits on what was the biggest environmental burden for this community, which is the former General Electric vast site, and just want to make people aware of that. And in that context, acknowledge that there are continuing impacts to the community or impacts that are being felt by and experienced by the community due to the presence of that facility and its impact to this day. And so while you don't see most of the buildings that were here of this vast campus, there should be a way to make sure that you're accounting for the fact that this community still feels very burdened by that. And the other burdens that I think should be taken into account are also the impacts of urban renewal, which affect many communities in Massachusetts and in particular affect Pittsfield and North Adams. And in particular, want to highlight that the West Side neighborhood of Pittsfield has the lowest life expectancy of any people in the county. And we're absolutely cut off from the city due to urban renewal projects in terms of burdens. I also just want everyone to be aware that in the past few years, we've had several groups form and succeed here, and I just want to recognize them. We have Blackshires, the Berkshire Black Economic Council, Latinas 413, Root Streams and Mustard Seeds, the North Adams Community Housing Organization, and then we have several longstanding organizations, including the Northern Berkshire Community Coalition, the Berkshire Immigrant Center, the Central Berkshire Habitat for Humanity, a very active NAACP chapter, and our very esteemed Berkshire Environmental Action Team, Jane Nguyen, who is here, and I would just want to acknowledge is retiring this year and has set, just an incredible legacy for Berkshire County. And I really want to thank you for having this meeting here, and we hope we see you again, particularly to meet these groups that are just working really, really hard to make our county a more diverse, more welcoming, and more vibrant place.
Thank you, Karen. I'm Jane Nguyen with Berkshire Environmental Action Team. I want to add one other community-based organization, the West Side Legends from the West Side. I also want to point out, when you're looking at community, please don't look at zip code. In Pittsfield, the life expectancy discrepancy is 12 and a half years between the census tract that has the lowest life expectancy and the more affluent census tract. So it's really important to do things by census tract, and we have been asking for nearly 2 decades to have the Mass Save program report by census tract, not zip code. And I can't stress how important it is. 12 and a half years difference in life expectancy. That should matter. Also, in many of our fights, we have watched lots of community benefit plans, but unless you have a signed legal binding agreement, they are blown off. And even with a signed agreement, unless you have a bond that's high enough to actually pay for what the company has said they will do, it's meaningless. I think it's really important to have good community benefit agreements, even if they take a long time. I know it's important to get stuff built fast, but you can't be doing what's happening to many communities without those. Also, when you're trying to reach out through small community organizations, please give us a lot of time. We try to use 5 weeks to get the word out to our partners so that they can get the word out. When you send something that's only 1 week, it's not enough time for us to get the word out. Thank you, and thank you also for coming out to the Berkshires. We really appreciate it.
No, thank you. Thanks for your comments. Thanks for your comments. So now we're going to move to close the meeting. If I can get a motion to adjourn.
I move to adjourn.
Thanks, Jen. Can I get a second?
Second.
Melissa Ferretti, second.
Thanks. Any discussion? Great. Sophia, do you want to do a quick roll call?
Yes, I'll quickly do a roll call to adjourn. Kalila Barnett,
Yes.
Madeline Fraser Cook,
Yes.
Melissa Harding Ferretti,
Yes.
Cheryl Hawley,
Yes.
Caroline Hahn,
Yes.
Lydia Lau,
Yes.
Marcos Luna, Peter Matthey, Sophia Owen,
Yes.
Jen Salonetti,
Yes.
Patricia Spence,
Yes.
Ari Zorn, and Miles Gresham,
Yes.
and Maria Belen Power.
Yes. We are adjourned. Thanks, Sophia.
Thank you, everybody.
Thanks all.
Night.
Officially. Thanks, Mike.
Yeah, no problem.
Are we going out west?
I gotta go. I'm gonna go back. I'm gonna